The government has gone ahead and passed 3 major laws to replace the Criminal Procedure Code and criminal laws of a previous colonial era. The proposed laws are seen to have some good features, but many that may raise concerns over the laws becoming even more draconian. Take a look at tonight's report on the new Criminal Procedure Code.
जो सदस्य विरोध में ना गए, मेरे विचार में निर्णय हाँ वालों के पक्ष में प्रस्ताव स्वीकृत और विधेयक यथा संशोधित पारित हुआ.
The Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Suraksha Sanhita, and the Bharatiya Sakshya Bill. The new laws to replace the British-era criminal law is passed by the Lok Sabha by voice vote. With 143 MPs suspended, the opposition benches were mostly empty when the debate on the bill took place on Wednesday. Home Minister Amit Shah claimed the new laws are citizen-centric, unlike the colonial-era code.
मोदी जी ने प्रधानमंत्री बनने के बाद गुलामी की मानसिकता और गुलामी के सारे चिन्ह इस देश में से जल्दी मिट जाए और नए आत्मविश्वास के साथ महान भारत की रचना का रास्ता प्रशस्त हो, इस पर आग्रह रखा है.
ब्रिटिश काल की गुलामी के सारे चिन्ह समाप्त कर इस संपूर्ण भारतीय कानून अब बनेगा.
So what will change once the bills become law? Here are the good bits. First information report or FIRs can be filed in any police station but in the same state or union territory where the crime is committed. The police must complete probe within 180 days. Courts will frame charges within 60 days and give verdict in 30. Under trials will be eligible for automatic bail after serving half their sentence. There will be a witness protection scheme for witnesses in sensitive cases. Women victims of crimes like rape can give testimony at home and their identity will be protected. There will be mandatory video recording of police searches. Now the concerns. Police can seek 15-day custody of suspect anytime within 60 to 90 days of arrest, depending on the offence. Currently, the police can get 15-day custody from the date of arrest. A court can proceed with trial if the accused does not appear for 90 days. The accused can also be convicted. Agencies can seize digital devices like phone and laptops during an investigation, which could erode right to privacy. Police get powers to attach property deemed as proceeds of crime. This could lead to arbitrary asset seizures based on suspicion. There are inadequate provisions for default bail. In other key changes, the definition of terrorism is changed to include damage to economic stability of the country and use of criminal force against public functionaries. The government has gone by past Supreme Court rulings and has not made adultery or gay sex a crime.
While these reforms signify a promising step towards a more equitable system as stated by the government, they also pose significant challenges in striking a delicate balance between citizens' rights and the criminal legal proceedings, which warrants a careful consideration of the proposed changes which are soon expected to come into force. Reporting from New Delhi, this is Nalini Sharma for India Today.
So let's try and decode the new criminal code for you. What's good? What's worrying in the new criminal code? Is it really citizen friendly, or are some of the changes draconian and giving the police and the government enormous arbitrary sweeping powers? I'm joined by two senior advocates, Aman Lekhi's former Additional Solicitor General at the Supreme Court, and Colin Gonsalves, senior advocate, Supreme Court, joins me. Colin Gonsalves, the government claims the proposed criminal laws are people-centric and that their main aim was to protect the constitutional human personal rights of citizens. The colonial laws have been done away. This is now the Bharatiya Nyaya Sanhita that will be citizen-centric. Why are you and other human rights activists so worried about these new laws?
Well, Rajdeep, if the British laws were colonial and draconian, I want to show you very quickly how the laws enacted by this government are 10 times more draconian. First, in British period, you could keep a person in police custody for a maximum of 15 days. This limitation was put because torture takes place in police custody. Now that 15 days has been extended to 90 days and more. That's a shocking provision enabling police torture. Third, the UAPA, Unlawful Activities Prevention Act, the terrorism statute provisions have been incorporated in the new law in toto. But two important safety provisions have been removed. First is the provision of sanction. Under UAPA, if you go under the terrorism statutes, under UAPA, after the police gather all the information and make the charge sheet, that charge sheet will not be filed until sanction is obtained by government, from government. In this law now, that very important precaution that sanction should be obtained has been removed. The second safety clause, which is the authority. In the UAPA Act, the terrorism statute, an independent authority looks at all the evidence gathered by the police and then after x-raying the evidence will decide whether the police should be allowed to file a terrorism charge sheet. This second safety clause, which Chidambaram introduced in Parliament, is now deleted. Next is FIR. I heard you speak on the FIR. The FIR is to be filed immediately on a citizen making a complaint of a cognizable offence. That is the 5-judge bench decision in Lalita Kumari's case. This was done because people go with complaints, very serious complaints, and the police do not register complaints saying that we have to do a preliminary inquiry. Now, Lalita Kumari said nothing doing. If you get a complaint, register it immediately. You don't do the preliminary inquiry till after you register the complaint. Now, in the new law, they go back contrary to the 5-judge bench decision and say the FIR will only be registered after the preliminary inquiry. Now look at the DK Basu guidelines. These were issued to make sure that when a person is arrested, he is not submitted to torture. All these 6 guidelines deleted. First, the identity of the police officer carrying out the interrogation was to be entered in a register. Deleted. The place and time of arrest was to be put in an arrest memo and signed by the arrestee, so that later on you can't say that this is not the place, this is not the time. Why was this introduced? Because the police would arrest and show the arrest, and 1 week later, after the person has been thoroughly tortured. Deleted. The injury report, where you're supposed to be taken to the hospital to make sure that torture has not been done, has to be signed by the arrestee. Deleted. The medical examination to be done every 24 hours, so that if any torture is done after arrest, that torture will show up in the medical report. Deleted. The memo of arrest and the health report showing injuries is to be sent to the magistrate within 24 hours. Deleted. These guidelines are to be shown at police stations. Deleted. Now I take you to the statements of the police, statements given to the police. Now these statements were never signed. Even in the British period, these statements were never signed because the police could force people to sign certain statements. And now what do you have? Videography. And videography is very tricky because you can tie a man's hands and legs to a chair and the videography will be from the neck upwards, and all that testimony will be taken as admissible in evidence. Legal aid from the point of arrest, not just when the matter comes to court. Legal aid from the point of arrest, riot victims' legal aid, all this gone. And you will only get legal aid at the time when the matter comes to court.
Effectively, what you're saying is it gives you claim the police far more draconian arbitrary powers rather than what the government is claiming, which is that it will result in police accountability. That's, the government says this will make the police more accountable. You're saying it will actually give sweeping powers without any safety clauses in place. Am I correct?
They say,
broadly.
Yes, and Rajdeep, 1 second. It's funny to hear them say colonial, colonial. So when you compare the colonial with the present government is 10 times more draconian than our British masters.
Okay, that's
unbelievable.
That's your subjective view. I want to focus only on the clauses. The worry, therefore, Aman Lekhi, that human rights activists and lawyers have is that this is going to give wide sweeping powers to the police without enough safety checks in place. Do you agree with that, or do you believe it was necessary to reform some of these colonial laws?
Well, Rajiv, there's many things which cause concern. There are some things which are good, but
what's good? What's good according to you? Because we've heard a lot of the bad
excess.
things from Colin. Tell us first what's good.
You see, as far as the good is concerned, insofar as certain other offences, particularly enhancement of the punishment and dealing with those private offences is concerned, there are certain changes which are positive. However, when we are dealing with these laws, particularly in the context of a polity which is in some way going to be affected by the state, the expansive and wide-ranging cause which entitles the state to interfere cannot be unreasonably enlarged. And that is where the problems are actually stepping. There are 2-3 points I want to make over here. One, this is a case sort of codification but recodification. Now this is very, very pertinent, because when you deal with recodification, you talk about how laws are developed and how aspects of law have become redundant or archaic. So that requires a scrutiny of the development of the law and development of the law to identify areas of concern. And areas of concern requires the collective participation and a reasoned deliberation, which is absent over here, apparent in the haste in which this whole thing has happened, and eventually it has been passed. So the basis of codification itself collapses. This is number one. Number two, insofar as the address is concerned, the address of the Home Minister is high on rhetoric and appeals actually to emotion. And I'll deal with one very significant aspect of it, where the Home Minister has made a distinction, in my opinion, a completely misconceived one, between Rashtradroh and Rajdroh, to say that, see, we've done away with Rashtradroh and we have only Rajdroh. Now, this is a completely misleading statement. Why? Because in law, there's a distinction between treason and sedition. As far as Deshdroh is concerned, that is treason. That is war against the state. Treason remains on the statute book. It was there under the old code. It remains under the new code. So as far as doing away with treason is concerned, that is wrong.
No, so they've not done away with sedition. They've not done away with sedition, actually widened its ambit.
No. They have not. First of all, they've retained, the basic distinction is wrong because treason is there. Number two, the description which is made of sedition is also wrong, because what is being suggested is that the old act permitted prosecution for acts protesting against governmental activity, which is again wrong, because as far as the old statute is concerned, there were two explanations, apart from a third which we are not concerned, which specifically excluded disapprobation of the government. It was not as if the law as it stood permitted the imposition of an offence of sedition mainly because you disagreed with the government. The problem with that law was not the content. The content which is there now is more or less similar to what was there earlier. The problem with that law was the ease of applicability, because the Supreme Court judgment had said that mere tendency, not intention, mere tendency could cause prosecution for sedition. So as far as the content was concerned, the content was defined. It was never allowed to transgress certain defined limits, and it did not cover criticism of the government. So this particular suggestion, to which there was much applause in Parliament at this distinction is concerned, is completely wrong. And it would have been more appropriate the person better versed in law dealt with this very technical aspect. Number three, even your program is talking about these are not colonial laws. Now, I have a very, very serious objection to this, because this suggests some kind of cultural hegemony of the past and internalization of some kind of subordination. What it ignores is that our laws are now distinctively Indian, and we have a very rich jurisprudence. And this jurisprudence is typically Indian, and there is nothing colonial about it. And the biggest tribute to that jurisprudence is that the altered laws draw upon the same law. It is not as if the content of the law has altered to say something different from what was understood earlier. The terminology has changed
Okay,
and the numbers have changed.
Okay.
So it is not a violent departure from the past.
You're saying it's not a violent departure, but Colin Gonsalves...
Now the problem with this... It is not a departure at all. Now the problem here is the fourth point.
Go ahead. Finish, Aman, with your fourth point.
You're saying something, Rajdeep. Yeah, the fourth point. The fourth point. You see, it is not the intent. Please understand, when we are dealing with penal laws, because the focus of the Home Minister was that we are motivated by the best of motives. But it is not the intent, but the expression. Because the worth of the law is in an application, and application draws upon terminology. So precision in terminology is absolutely basic and goes to discretion. The manner in which they are drafted, insofar as the terminology is concerned, concedes to the executive powers, which can be expansive and therefore cause more than necessary interference with liberty. Now, if that is so, that will be an undemocratic, forget colonial or
I take your point. I think both of you are virtually expressing similar concerns. In a sense, Colin Gonsalves, the fear therefore you all have is that rather than reforming the police, which is really the way to deal with the criminal procedure code and which is what the Supreme Court has recommended, you believe this is only going to end up giving more discretion and arbitrary powers to the police to arrest, particularly under potentially draconian laws, because terrorism, for example, will also, corruption, organized crime will come under the ambit of ordinary criminal law. So you use the provisions of UAP and bring them under this law and thereby expand the powers of the police. Am I correct?
Correct, Rajdeep, and more important than that is the government at the highest level that's supposed to be honest and transparent with people is telling the people that we are reforming. We are making the law more Indian and better. Now look at the sedition law. Supreme Court stayed sedition. Why? Because words, strong words, people were being arrested for sedition. But sedition law in India under Kedarnath's case says strong words is not good enough. You cannot prosecute a person for strong words. It has to be strong words combined with violence. Now you look at the sedition section, they've introduced the same British law. Whoever by words attacks the government, etc., etc. But attacking the government by words is not a crime and it's not sedition. Look at gay sex. The Supreme Court read it down. Gay sex, which is voluntary, non-coercive, is not a crime. And now again they sneak in the same old section that on gay sex, because they can't get over the fact that the Supreme Court had declared that section unconstitutional. Look at false arrest. A false arrest can have a person in jail for 5-6 years. Guess what the fine is under this present government? The fine for false arrest is 1,000 rupees. So Rajdeep, they're just bluffing the country, fooling the country with their words and their rhetoric and their speeches. But the law remains much more draconian than the British. This is worse than the British.
Those are very strong words, and those words hopefully will prompt a wider discussion. We will continue having that discussion on these shows in future programs. This is a law which should have been really had a sustained discussion in Parliament. What else have we seen? Suspension, unfortunately, of opposition MPs and the bills being pushed through. Once again, it's for you, the viewers, to judge whether that's the right way forward. Colin Gonsalves, Aman Lekhi, for giving us an initial legal perspective to these new laws. Thank you very much.